Good afternoon. Welcome to everybody, both here in Greenway and joining us online. My name is Scott Goodman. I'm joined this afternoon by two of our outstanding commercial juniors, Jonathan Dooley and Carmel Lee. Jonathan's career at the bar, career before he joined the bar, included working with Justice Bergen when Her Honour was the commercialist judge of the Supreme Court, and a number of years as a commercial litigation solicitor at a national firm. In 2014, Jonathan came to the bar and has since developed a wide-ranging practice, commercial equity-based, including insolvency, insurance, real property and class actions. Carmel's pre-bar career was also quite varied. She was a Deputy Registrar in the Supreme Court and the Court of Criminal Appeal. She worked with a number of judges in the Supreme Court and the Court of Appeal. She also worked in the Crown Solicitor's Office and lectured at Sydney University in Conflict of Laws. Since Carmel came to the bar in 2012, she has also developed a wide-ranging commercial equity practice, including in property law and regulatory crime. Tonight, Jonathan and Carmel will deploy their commercial expertise in their presentations concerning the COVID pandemic. The focus of what would otherwise be a very wide-ranging discussion focuses on the response from two bodies. First, the response from the legislature. For example, some of the changes to the Corporations Act, which provide protection for directors and companies. And second, the reaction from the courts. You'll hear from both of them a selection of cases in which COVID has featured, and you'll hear from Carmen in particular about some of the procedural aspects, including when the court is likely to entertain an adjournment application. Both Jonathan and Carmel are happy to take questions, so please feel free to interrupt on the way through, and there'll also be an opportunity at the end to raise any questions. For those of you joining us remotely by Starleaf, if you raise your hand when you have a question, we will be able to attend to it straight away. So with that introduction, I'll hand over to Jonathan.
Thanks, Scott. Good evening, everyone, both here and online. I'll be looking at some insolvency and commercial issues that arose since the world met with COVID. There were many things to learn in 2020. An improperly fitted face mask can be a nightmare or even a traffic hazard if you're driving and wearing glasses. TikTok, it's not just a sign you make to get your kids to hurry up, to get ready for the beach, even when they've barely managed to get one shoe on each after 10 minutes. And to get out of your great aunt's birthday, you don't have to pretend to have gastro. You can just say you've got a sniffle, have had a COVID test, and have to self-isolate. It then becomes your civic duty to watch Netflix, perhaps Tiger King, and apparently for Victorians to get on the beers. There were additionally a few laws passed, some of which have come and gone, and others are just beginning, and there were some judgments delivered, and this paper takes a look at some of those. There are 4 parts to my paper, or speech. First of all, I'm going to look at amendments to statutory demands and bankruptcy notices, most of which have been phased out now. Secondly, I'm going to look at a new safe harbour provision for insolvent trading. Third, I'm going to look at some new laws which came into pass in January 2021 in relation to small business restructuring and streamlined liquidations of small businesses. And the last section will look at a few cases. So to go now to the first part, on the 25th of March 2020, the Coronavirus Economic Response Package Omnibus Act 2020 was enacted. It was initially in force for 6 months, but the changes were subsequently extended to 31 December 2020. For statutory demands, there were two reasonably significant changes. First of all, one could not issue a statutory demand unless the debt was $20,000 instead of the previous $2,000. Secondly, recipients of statutory demands had 6 months to respond instead of the earlier 21 days. So the upshot was probably that a lot of statutory demands were put at the bottom of the in-tray. Of course, another upshot was that companies that might otherwise have had some serious difficulties in continuing to trade would have been able to keep on trading, even if they might be what are hopefully affectionately known as zombie companies. Now that those regimes have been lifted, the forthcoming year and subsequent years might present difficulties for those companies that might be financially on the ropes, as statutory demands will probably, one would think, be agitated again, and some that were not served during the effectively moratorium period will now be on their way in the mail. Bankruptcy notices on individuals were also modified in similar ways. First of all, the amount required to issue a bankruptcy notice was changed from $5,000 to $20,000. The period was similarly extended from 21 days to 6 months for responding to a bankruptcy notice, and likewise, the period for protection on the presentation of a declaration of intention to present a debtor's petition was changed to 6 months rather than 21 days. Since 1 January 2021, for bankruptcy notices, the $5,000 threshold has permanently been doubled to $10,000 by the Bankruptcy Amendment, open brackets, Bankruptcy Threshold, close brackets, Regulation 2000. As mentioned, the new laws went out with a bang at the same time as the fireworks on the Harbour Bridge. 2021, and perhaps the next couple of years, one would think we'll see some increased action in this space. In addition to those laws, there was a new safe harbour provision enacted in the Corporations Act. This was in addition to an earlier safe harbour defence inserted in September 2020, being Section 588GA, and that concerns taking a course of action reasonably likely to lead to a better outcome for the company. The new one, Section 588G subsection 1, provides that Section 588G2, which concerns the director's duty to prevent insolvent trading, does not apply in relation to a debt incurred by a company if the debt is incurred on the satisfaction of 3 conditions. First of all, the debt must be incurred in the ordinary course of the company's business. Secondly, the debt must be incurred in the period 25 March 2021 to 31 December 2020. And third, the debt must be incurred before any appointment during that period of an administrator or liquidator of the company. Under the defence under Section 588G subsection 2, the defendant has an evidential burden for these matters. One would think that in most cases, the main area of dispute will be whether the debt was incurred in the ordinary course of business, which the defendant will have to prove. That is, the date of the debt, and whether prior to the debt a liquidator or administrator had been appointed, one would think are often likely to be less contentious as they will be reasonably ascertainable by bank records and the like. As at the date of writing, or yesterday, which is the last time I checked, there were no cases that I could see dealing with the section. The first concept, the ordinary course of business, is one that is used in other parts of the law, such as unfair preferences and partnerships, and it seems reasonable to assume that at least some of those concepts will ultimately be deployed by the courts when considering the nature of the defences under Section 588G. To just give a flavour of some of those concepts, in Taylor and White, a 1964 judgment of Chief Justice Dixon, His Honour said that the expression "in the ordinary course of business" refers to business as a general concept and is not restricted to the conduct of a particular type of business. Rather, it is referring to the transaction of business as a known and recognised activity pursued by anybody engaged in an attempt to win or earn or make money or living in a systematic and regular way. The phrase "in the ordinary course of business" is meant to refer to transactions regularly taking place in a sustained course of activity or some usual process passing without examination. There are also a couple of principles in a judgment of Justice Priestley in a decision of Harkness and Partnership Pacific. His Honour said in that case, the ordinary course of business raises the question, would an objective observer, knowing the actual business facts of how the particular payment came to be made, regard it as one in the ordinary course of business, thus implying an objective test rather than necessarily a subjective one, informed by the business, however. And His Honour also noted that the normal procedures and practices of the parties' businesses and the trade in which they operate, as well as the dealings between them, are not irrelevant. Evidence of such matters is necessary so that the court may consider the payment in question in its factual context. Of course, a test of this type is likely to turn in any case on the factual material put forward by the parties, and again, it is a test that the defendant would bear the onus in establishing. The third part of my address today is concerning the new laws which came into place on 1 January 2021. And there have been two changes for distressed companies that have been affected by amendments to the Corporations Act and the Corporations Regulations. One is a new restructuring regime for small businesses, and a second regime is a streamlined liquidation process also for small businesses. The new restructuring process is located in a new Part 5.3 Capital B of the Corporations Act. It's directed at companies with liabilities of less than $1 million and is only available if the directors and former directors have not been the subject of restructuring or simplified liquidation within the last 7 years, and in addition to the directors, if the company itself has not been the subject of restructuring or simplified liquidation in the previous 7-year period. And that's in Section 453 capital C and Regulation 5.3 capital B. The regime contemplates the business developing what's called a restructuring plan, and that's with the assistance of an insolvency practitioner under Section 452 capital A. Unlike, however, an administration or liquidation, the insolvency practitioner does not take over control of the company. Rather, it's just to assist the actual directors to develop the plan. Section 453 capital E provides that the functions of the restructuring practitioner are first, to provide advice to the company on matters about restructuring, second, to assist the company in preparing a restructuring plan, and thirdly, to make a declaration to creditors in accordance with the regulations in relation to a restructuring plan proposed to the creditors. The proposal of a restructuring plan is itself an act of insolvency, and that's under Section 455 capital A subsection 2. During the restructuring period, statutory moratoria are made available, as is the case in other forms of external administration, such as on automatic stay of proceedings under Section 453 capital S, and suspension of enforcement processes, Section 453 capital T. Those are just a couple, and there are others. Under Section 458 capital A, the court has a discretionary power to make such order as it thinks fit, appropriate, as to how this part is to operate in relation to a particular company, which is also seen in other parts of insolvency law. Voting on the restructuring plan takes place on the papers under Reg 5.3b.21, and the threshold for acceptance of a restructuring plan is a majority in value to the last day of the acceptance period. That's 5.3b.25. And once it's made, the restructuring plan has the effect of a deed, and that's provided for in 5.3 capital B 26 to 28. If the plan is fulfilled, the effect of it is that the company is released from all admissible debts and claims, Reg 5.3 capital B point 31. Thus, on the fulfillment of the plan, the company that takes advantage of it can resume to normal trading and commercial life. There is also a temporary safe harbor provision in Section 588G(a)(c), which provides protection to directors in respect of companies who are eligible for temporary restructuring relief, a term discussed in Section 458 capital E, where those companies are seeking to take advantage of this new regime, and they've taken all reasonable steps to appoint a restructuring practitioner. In those circumstances, if a debt is incurred in the ordinary course of the company's business, Section 588G subsection 2 does not apply. As with the other defence I mentioned a couple of minutes ago, the defendant bears the evidential burden in respect of this defence. To turn now to the streamlined insolvency process, that's set out in Section 500 capital A to Section 500 capital A capital E and Regulation 5.5.01 and following. It is available for companies with certain characteristics, including their liabilities not exceeding $1 million, and that's Reg 5.5.03. The main features of the process are, as set out in Section 500 capital A capital E2, subsection 3, and Reg 5.5.05. First of all, meetings of creditors are not held. Secondly, there is no committee of inspection. Thirdly, there are reduced obligations on liquidators to investigate the company's affairs and make reports to creditors. And fourthly, there are some limitations on the operation of avoidable transaction provisions. One can see how the streamlined liquidation process might create more efficiencies in the winding up of smaller companies, with the aim of increasing any return to creditors and similarly reducing the workload and cost of liquidators in such cases. The fourth and final part of this speech is to take people through a few cases where COVID has been in the courts, fortunately not infecting the judiciary. COVID has been everywhere, of course, and one reason that the courts have been closed is the rapid adoption of video conferencing and the willingness of courts and litigants to adopt and use emerging technology, which may have resulted in 10 years of incremental change taking place in 10 months. There have been a number of cases delivered which have COVID as a centrepiece, although what has occurred to date is no doubt an amuse-bouche of what will become a 12-course degustation menu, hopefully with matching wine set, of COVID-related cases that will come up in the next few years. Here are three that I thought were worth a look. The first case is the HDI Global Specialty SE and One Canna number 3, Proprietary Limited, which is a Court of Appeal decision that probably everyone's heard of from late last year. That was a test case for a business interruption policy, which had two policyholders as the test cases. The insurers argued that the claim under the policy was excluded from coverage. The relevant exclusion clauses, however, refer to the Australian Quarantine Act 1908 and subsequent amendments to that act. The problem for the insurers was that the Australian Quarantine Act 1908 had been repealed prior to either policy by the Biosecurity Act 2015. And it was under that 2015 Act that COVID was the subject. The proceedings weren't actually heard by a first instance judge. They were removed immediately by Justice Hammerschlag up to the Court of Appeal, and somewhat unusually, but perhaps not surprisingly in a case of this magnitude, it was heard by a 5-judge bench, which was constituted by Chief Justice Bathurst, President Bell, and Justices Marr, Hammerschlag and Ball. The main issue in the case was whether the reference to the 1908 Act and the subsequent amendments, as appearing in the exclusion clause, should be construed as extending or referring to the 2015 Biosecurity Act, or whether the references to the 1908 Act were an obvious mistake. The Court of Appeal found against the insurers. The essential reason was that the 1908 Act had been repealed, and the words in the exclusion clause and subsequent amendments meant and subsequent amendments, not a new act which replaced the 1908 Act. And that emerges particularly from Justice Hammerschlag's judgment at paragraphs 119 to 121, with whom the Chief Justice and the President agreed at paragraph 2, and Justices Marr and Ball said that they substantially agreed with that reasoning at paragraph 7, but in addition, their honours offered a separate analysis. As to the question of any mistake in respect of using the repealed 1908 Act in the exclusion clause, Justices Marr and Ball concluded that there was no mistake in the language of the clause as to the expression of the party's intention, even if it were right that the parties made an incorrect assumption as to the 1908 Act being in force. Just to unpack that, the parties intended on that reasoning to refer to the 1908 Act, but they just got it wrong. Or put another way, refer to an act that had been repealed. And that emerges at about paragraph 61 to 65 of their judgment. Justice Hammerschlag, in considering that point, considered that the wording was not a clear mistake. And if it was a clear mistake, then it did not rise to the level of absurdity. And saying in I think a reasonably useful statement of principle, that the court does not substitute, by way of construction, its own commercial judgment for that of the parties. And that's at about paragraphs 126 to 127. Chief Justice and President Bell, in their joint judgment, which was quite short, effectively agreed with the other judges that the orthodox principles of contractual construction, such as the absurdity point discussed by Justice Hammerschlag, were not so flexible so as to admit of the insurer's argument on this point. That's at paragraph 5. The upshot was the proceedings were dismissed, and there does seem to be some publicly available material indicating that the insurers have sought special leave to appeal to the High Court. So that story might still have a bit to go. The second case I was going to talk about was also concerning an exclusion clause of a business interruption policy, decision of the full court of the Federal Court of Rockman, Proprietary Limited, and AAI Limited, trading as Vero Insurance, 2020 FCA FC 228. In this case, the full court of the Federal Court, constituted by Justices Bizanco, Darrington and Colvin, considered such a clause. Was put to the court in this case as a separate question, namely as to whether an exclusion clause in a particular policy was engaged if, broadly speaking, the loss claims by the insured arose from a human disease, here COVID obviously, which had been specified in the declaration of a human biosecurity emergency made under the Biosecurity Acts 2015. So I'll unpack that a bit. One has the declaration specifies COVID, and the argument was if the loss arises from the disease specified in the declaration, then the exclusion clause was triggered. The full court said no to that separate question. However, at about paragraph 65 onwards, it emerges that the reasoning of the decision will have limited precedential value due to the way in which the case is argued below and the phrasing of the separate question, having regard to the wording of the policy there under consideration. And that was particularly emphasised by the full court at about paragraph 65. Ultimately, at paragraph 69, the full court said that the separate question could not be answered in the terms sought by the insurers, saying it is not sufficient to exclude cover under the exclusion if the claim is somehow causally connected to a human disease specified in a declaration of a human biosecurity emergency. And as one often sees in cases about causation, the full court went on to say, the question of causation is a matter of fact to be determined in the circumstances of each particular case. Therefore, this case stands to the proposition that for the wording of that particular exclusion clause, the mere presence of some causal connection to COVID after having been specified in a relevant declaration is insufficient, and proving whether a claimed loss was within the exclusion would have to be done on a case-by-case basis. The third case I was going to talk about, and will talk about, is in the matter of Riles Hotel, which is a decision of Justice Black of the Supreme Court. In this matter, the plaintiff was a lessor and it applied to wind up the defendant in insolvency, or alternatively on the basis that it was just and equitable to wind up the defendant. The defendant was the lessee of a hotel, and part of the hotel was used for student accommodation. There was a shortfall in the rent, and as Justice Black succinctly said, the hotel, unsurprisingly, has little student or other occupancy in the midst of a pandemic. Undeterred by the legislative changes referred to above, the lessor went to court and proceeded to seek to wind up the lessee. In analysing the case, Justice Black found that the lessor had failed to establish that the lessee was insolvent, and His Honour also rejected the winding up on the just and equitable ground. However, more broadly, His Honour considered that the winding up application itself was an abusive process. First, His Honour said that it was so because the lessor had not sought to renegotiate the lease as required by regulations made under the Conveyancing Act 1919, which was one reason. And His Honour also said that the presence of a substantial dispute concerning the underlying debt was an inappropriate matter to determine in a somewhat summary proceeding of that nature. He went on to say even further that irrespective of those matters, His Honour would have dismissed the application or adjourned it for 12 months under the Court's power under Section 467, on the basis that the legislature had passed laws seeking to narrow the basis on which companies could be wound up during the pandemic, and the application here was an attempt to sidestep that outcome. In the subsequent judgment, an order for indemnity costs in a gross sum was made against the plaintiff. By way of concluding remarks, it is unlikely that 2020 will be remembered for its temporary changes to insolvency regimes. It's also inevitable that we're just seeing the tip of the iceberg when it comes to the impact of COVID-19 on the courts. No doubt 2021 and the next few years will bring unanticipated fact scenarios and throw up interesting and challenging issues concerning statutory and contractual interpretation and its impacts on parties' rights and liabilities. By then, hopefully, all the home improvement projects that went hand in hand with the pandemic will be finished, which reminds me I've got to do the lawns this weekend. And with that, I'll hand over to Carmel. Oh, are there any questions? I'm happy to deal with them at the end, but equally happy now.
Can I raise one, Jonathan? You mentioned that there was a section within Part 5.3b that gave the court power essentially to do whatever it likes with respect to a particular company. Have there been any cases that have given any guidance, or is there any guidance from elsewhere that we can draw upon?
Thanks, Scott. Would people have heard that, Matt? Okay, great. Sorry, just wanted to check that the audience may have been in the dark. Yeah, so I was referring to Section 458 capital A, and there are Section 447 capital A is materially identical, and that's been the subject of quite a lot of judicial discussion in the context of administrations. And the courts have held that that power is wide, but not entirely without limit. One High Court case analysing it is Australian Memory and Bryan. So paragraph 24 of that case, the High Court said that the legislative intention was to permit alterations to the operation of the part, indicating a pretty wide power. And also the section does not preclude the court from making an order with a future effect in relation to past matters. And one would think those cases will inform Section 458 capital A, and therefore the court will consider itself to have quite wide powers to tailor the regime according to the circumstances of the particular subject before it. If there's no other questions from those online or in the room, I might hand over to my learned colleague Carmel. Thank you.
Thank you, Jonathan. I've written a fairly detailed paper for today. I don't intend to read out that paper. I will be referring to some parts of that paper and encourage those listening to this talk to look at that paper as well for the exact quotes that I refer to. Unfortunately, I butchered Gabriel Garcia Marquez's famous novel for the title of the paper, so apologies for that. It's quite clear that the COVID-19 pandemic has changed the environment in which businesses operate, and it's changed the commercial focus of many of those businesses. It's changed not only the way in which they're told they're allowed to conduct their business, for example in compulsory government shutdowns, but it's also changed their particular values and priorities when it comes to those businesses as well. An example of that is the rise in people working from home and remote working, which has led to less of a need for commercial lease space, for example. There's been a number of papers written throughout last year and into this year about this phenomenon, and a lot of those papers have been written, understandably, about interpretation of contract. So when clients are looking to their contractual obligations, how might they be able to get out of those obligations? I think that some of those remedies it's difficult to present a general paper on, such as force majeure provisions, termination provisions, and variation clauses. Each of those will depend really on the exact clause in the particular contract that you're looking at. But I think that one part which can be spoken about broadly, one remedy that can be spoken about broadly is that of frustration of contract. And so I'll be speaking about that today. But broadly I'll be speaking about three things. First of all is to look at commercial leases as an example of a contract where parties have been seeking to negotiate and renegotiate the terms on that, which of course means that I will have to look at some of the legislation behind that scheme. The second one will be the doctrine of frustration. And the third one is the procedure of running commercial litigation, which we've seen has changed dramatically. As Jonathan said, we've had 10 years of development in the space of 10 months, which I thoroughly agree with. So I'll be looking at when an adjournment application is likely to succeed and when an adjournment application is likely to be refused and why that will be. We noticed that there was significant legislation introduced last year in relation to commercial leases. The mandatory code of conduct contained a number of good faith leasing principles. And that code was given force in New South Wales through a number of amendments to the Retail Leases Act in New South Wales and the Retail and Other Commercial Leases Regulation. That regulation was updated a number of times, chiefly to extend the deadline in which that scheme would take place. The Retail and Other Commercial Leases Regulation inserted Schedule 5 to the Conveyancing General Regulation in New South Wales. It referred to impacted leases and it was for a prescribed period. That regulation currently ends on the 28th of March of this year. In short, it required parties to be a party to a lease of a premises used for a commercial purpose, to qualify for the JobKeeper scheme, and to be part of a corporate group where the turnover in the 2018 to 2019 year was less than $50 million. The schedule prevented lessors from commencing action against an impacted lessee for failure to pay rent or other outgoings, and also for being in breach of opening hours that were specified in the lease, particularly of importance to those as part of large commercial shopping centres, for example. Parties to commercial lease were also given the option to request a renegotiation of terms impacted by the COVID-19 pandemic, including the rent rates. But significantly, the schedule did not impact a lessor from commencing actions that were unrelated to COVID-19. There's been a number of cases that have come up in relation to the COVID-19 regulations. Possibly the most useful of those has been the Sneaker Boy cases, Sneaker Boy 1 and Sneaker Boy 2. These are quite significant in terms of the COVID regime. They go through in a detailed way, examine that regime and how it operates. And they're also been quoted in subsequent cases that have come up in this area. Briefly, the events that happened in the Sneaker Boy cases took place in the height of the Sydney lockdown in April of 2020. Sneaker Boy was a lessee of retail premises that was owned by George's Properties. Sneaker Boy experienced a decline in revenue due to COVID-19 and it removed its stock from the premises. The lease was terminated by a landlord. Significantly, it was terminated for two reasons. The first was non-payment of rent, the second was abandonment of premises. In the first case, the court found that removing stock from the premises did not constitute an abandonment of the premises, but it was a decision to temporarily cease trading because of the COVID-19 restrictions. That left them with only the non-payment of rent, and the court found that the normal principles concerning relief should be applied, that if the only grounds of termination is rent being in arrears, then relief should be granted. Significantly, all these events applied before the regulation came into effect, and the court indicated that had the regulation applied at the time, the termination of the lease would have breached that regulation. In speaker point number 2, that case referred to, significantly, the bank guarantee. The landlord had used part of the bank guarantee and drawn upon the bank guarantee to pay the rental arrears. This case was in relation to what the replacement bank guarantee should be. And the court found that the replacement bank guarantee should be reduced because the bank guarantee was calculated on 10 times the value of the commercial lease. So 10 months rent was the bank guarantee. 10 months rent was the bank guarantee. If the rent had been reduced because of the COVID regulations and the COVID scheme, then that bank guarantee as a result had to be reduced as well. Significantly, the court looked at the tenant's trade, which informed the percentage of the way that rent would be reduced, included both turnover from the leased premises and also from online sales. Now, I refer to that decision as a good way of breaking down those calculations for the reduced rent. An example of attempting to avoid commercial costs incurred under lease arrangements during the pandemic can be seen in NTT Australia Digital Pty Limited and cover Genius's services. I like to think of this case as being one of just horrific timing for all the parties. In that case, the plaintiff was a tenant of other space, and through a deed of assignment, the NTT assigned the lease to cover Genius's systems. Cover Genius's systems, CGS, signed the deed on the 7th of January. The deed came into effect on the 1st of May 2020. Between the end of March and the end of April, CGS communicated with the landlord, trying to obtain some form of rental reduction or some form of assistance. Initially, they sought 100% waiver of rent and outgoings due to the impact of the pandemic. Later, significantly in this case, one of the parties tried to run a claim for frustration, which was later abandoned, which will be interesting when we look at the frustration cases. NTT sought an order for specific performance of the deed by CGS, and the court was asked 4 questions. The court asked, is the deed valid and enforceable? Is NTT entitled to specific performance? Is CGS liable to indemnify NTT? And is the landlord entitled to call upon the NTT bank guarantee? The court answered those questions in the following way. First, the deed was valid and enforceable against CGS. It was validly executed, and CGS's conduct after the execution of the deed supported the idea that they intended to proceed with the deed, and they regarded it as being enforceable. They immediately spent large amounts of money on the fit-out of the premises. They moved their staff into the premises, and they continued in correspondence with the landlord to refer to their obligations under that deed. The lease was due to, in relation to specific performance, the court declined to enforce specific performance. This is for a number of reasons. Significantly, the lease was due to terminate in August of 2021. So it was a fairly short period of time, a fairly short commercial lease. There was some doubt as to whether damages would not be an adequate remedy. And the specific performance, the court found, would result in significant hardship to CGS. The court also was reluctant to order specific performance in circumstances where specific performance relied on the consent of a third-party financier. So in this case, they required a bank guarantee, and CGS was in the midst of an economic crisis caused by the pandemic, and they were accompanied with little or no asset backing. So in that environment, it would be difficult for them to get a bank guarantee to service what was really a fairly short duration of a lease. And the court emphasised that in relation to declining to order specific performance. However, it did find that NTT would be able to claim in damages. And CGS was liable to indemnify the NTT pursuant to the deed. CGS, in relation to the bank guarantee, the court went through a detailed examination of the COVID-19 regulations. And I'd refer you to the judgment. It goes through those regulations in quite significant detail and is quite a useful exercise if you're considering applying under those particular regulations. But ultimately the court found that CGS should not be entitled to rely upon those COVID-19 regulations. And the reason for that was for a very simple reason. And that was simply because of Uniform Civil Procedure Rules 14.14. That was because CGS had not raised that in their amended defence. They'd come to the expedited hearing, they'd raised the argument for the first time at the expedited hearing. And the court found that whether or not it was an impacted lessee under the regulations, whether or not it was eligible to apply for JobKeeper under the JobKeeper scheme, and the turnover were all factual considerations. If NTT was forced to, if this was allowed in, then NTT would be prejudiced because they'd be unable to test CGS's claims of eligibility. They had no notice prior to the hearing that these particular matters would be raised by CGS. Interestingly, the court then, having made these particular findings, referred the parties to mediation. So the parties then, with the aim that the parties reached a particular agreement that accommodated the interests of all the parties. And costs were followed to follow the event. CGS bore the costs of the proceedings in that particular case. Sorry, the last case in relation to that is First Renewable and Novitsky. In that case, the tenant, First Renewable was the plaintiff of Novitsky's premises, and against that agreement, First Renewable sublet the premises. Novitsky re-entered the premises, and First Renewable sought relief against forfeiture. The court declined to grant that. The court found that, and this was a great example in looking at, the regulations don't cover every ill. The Retail and Commercial Leases regulation did not apply to cases involving a breach of a lease covenant unrelated to the payment of rent. In this case, they'd sublet the premises without the permission of the landlord. It was not related to the COVID pandemic. They're entitled to re-use the premises. I've noticed a lot of discussion in relation to frustration of contract since the beginning of the pandemic. And I find it very interesting in looking at this by being approached by commercial clients or discussing these issues with other practitioners to go back to the very basic first principles of frustration to then see if it now applies in a new novel situation, the COVID-19 pandemic. Probably the best definition that I found is that in Davies Contractors, it's been quoted ad nauseum by many courts, and that is that frustration occurs whenever the law recognises that without the default of either party, a contractual obligation of a party has become incapable of being performed because the circumstances in which performance was called for would render the thing radically different to that which was undertaken by the contract. In the Latin term, it is that this is not what I promised to do. So the number points to that. There's an unforeseen supervening event, possibly the COVID pandemic. It's not caused by either party. It makes performance of the contract impossible, or it's radically different to what's agreed upon by the parties. And significantly, it ends without damages due to either party. So I find those three authorities incredibly useful for explaining frustration and reducing it back to the very first principles. Probably my favourite one is Taylor and Caldwell. It's the clearest of the three. In Taylor and Caldwell, the plaintiff hired a music hall from the defendant for a concert. An express term of the contract was that the premises would be in a fit state for the concert. They've hired a music hall, they want to make sure that it's fit to actually hold the concert. They're only hiring a music hall to put on the concert. Before the concert was due to take place, the hall was destroyed by fire. In that case, the court found that because the music hall had been destroyed, the contract was frustrated. There's a reasonable expectation of the contract based on the continued existence of the music hall. The contract is clearly frustrated. Where you're going to hold your concert is now a pile of ruins. It's a very clear example of a frustration of contract. Krell and Henry is another great authority. I think it's particularly useful when we consider public events that have been cancelled because of the COVID pandemic. This concerned the contract for the use of rooms on Pall Mall, to which a planned coronation of King Edward VII was due to pass under. The contract for the use of the rooms it was held was frustrated because the procession was cancelled because of the King's illness. In short, the value of those rooms was that you were going to have a fabulous view in watching the King's coronation pass underneath. the king becomes ill, the coronation doesn't happen, you're left with some fairly ordinary rooms with a view to the street. The entire purpose of the contract has been frustrated by the king's illness. Chapman and Taylor is another great authority, very useful for looking at contract for personal services. In Chapman and Taylor, Chapman had entered into a contract for residential building work. The contract was to be performed by Chapman personally, or by another person under his supervision. Chapman became injured on another work site, he went into a coma, he was unable to continue those tasks. And for a period of time it was unknown when or if he would come out of that coma. It was held that the contract was frustrated. He was unable to undertake the work personally or supervise the work that was required. In short, the contract would have been radically different to that which had been promised. I think that most practitioners will be aware, of course, that in advising the clients in their legal positions, the clients need to think about their actual commercial environment that they're in. Is it in their best interests to claim frustration of a contract? Some things that they might consider is whether the whole or the part of the contract is being frustrated, and I'll look at that coming up. The length of time in which the contract has been frustrated compared to the duration of the contract, and following up from the first point, and the impact of that termination of contract for frustration on the possibly ongoing commercial relationship between the parties. Obviously, suing another party with frustration of a contract may sour that commercial relationship. Is the action worth souring that relationship for, or are you risking a potentially very profitable ongoing commercial relationship? The case that I've listed, I think, is a particularly interesting one. Li Qing-wing and Yang Yi-yong is a Hong Kong case, and it asked one principal question, that was, what relation does the likely period of interruption bear to the outstanding period of performance? It's quite interesting on its facts because it concerns frustration of contract in the context of the SARS pandemic. So the facts are also quite interesting compared to the current situation. In that case, the plaintiff owned a flat in a residential development. The plaintiff leased the flat to the defendant for a period of 2 years. In March of 2003, several residents became ill with the SARS virus and the defendant moved out of the flat. The Hong Kong Department of Health ordered that the relevant block of the apartments was to be isolated for 10 days. This all sounds somewhat familiar to the COVID situation, doesn't it? The defendant returned to their rented premises after the 10-day period. The defendant claimed that the tenancy agreement had been frustrated by the making of the isolation order being the 10-day period. And in judgment, Justice Locke asked, what relation does the likely period of interruption, that 10-day period, bear on the outstanding period of the performance? In this case, His Honour found that because the isolation order lasted for 10 days, that was a 10-day period out of a 2-year lease. And as a result, the contract had not been frustrated. As I said, it's quite an interesting case given the SARS virus, but it's also been those concepts have also been picked up in Australia as well. There's an interesting case in Australia that picks up many of those principles, and that's from the District Court of Queensland. It's not on the slide, I'm afraid, but it's at paragraph 37 of the paper. That case is Happy Lounge Pty Limited and Choi and Lee Pty Limited. And in that case, it demonstrates some of the difficulties that some of the parties will face in bringing a claim for frustration. The applicant entered into a contract to sell a business to the first respondent. The business was carried on in Fortitude Valley, one of the main entertainment areas of Brisbane, and it operated as a bar and a lounge. By the way that I've read the judgment, it sounds a bit like a nightclub. It's open till 3 o'clock in the morning. The public can purchase food, drinks and enjoy some entertainment. Significantly, there was no ability to sell takeaway food at the premises, and there was no bottle shop either. On the 29th of January, the Queensland Health Minister declared a public health emergency in relation to COVID-19. And there was a series of public health directions after that point. The respondents claimed, in amongst a number of other claims, the respondents claimed that the contract had been frustrated. The respondents specifically pleaded that the frustrating event occurred on one of a number of dates on which the Chief Health Officer issued a public health direction. And they said that radically changed the nature of the contract. Justice Rosingen was not sympathetic to the respondent's claim, and I've included a quote from the judgment, paragraph 41 of the paper. The judge's reasons are very similar to those in the previous case from Hong Kong that I mentioned. And that is that she looked at the effect of the public health direction and looked at the period of time that it would prevent the respondents from carrying on a business. She said, look, it was an indefinite, albeit a temporary period. She looked at the fact that the lease and the premises would continue till August of 2032. So it's a 12-year period that the lease is going to continue on for, and that it has the option to extend beyond even that. So they're in the premises for at least 12 years. The period of time for the frustration of the contract has been perhaps a couple of weeks, at most perhaps a couple of months. So she's taken the same reasoning from the UK case and said that the contract is not frustrated because you need to look at the length of the period of time in which that person has not been able to use that premises. Finally, looking at adjournment applications over this period of time, having looked at commercial lease arrangements and contracts, how do we bring cases into the court, and when will parties be given adjournment? Special provisions were inserted into the Evidence, Audio and Audiovisual Links Act in 1998 through Section 22C. In short, the court's power to direct a witness to appear by audiovisual link during a pandemic. The courts to have regard to the interests of justice significantly, and including any public health risk posed by the COVID-19 pandemic. And that remains in force until 26th of March in 2021. Significantly, as you'll see from the different cases that follow, the court has really relied upon its usual go-to parts in legislation for Section 56(3) of the Civil Procedure Act and Section 37M, subsection 3 of the Federal Court of Australia Act. Section 56, of course, being just, quick and cheap. The court must balance the interests of justice, and it must operate in such a way, the overriding purpose being the interest of justice, that it be just, quick and cheap. So we've seen a number of examples of when adjournments have been granted. The first one is when a witness would be required to give evidence by an audio-visual link from China due to Australians' travel restrictions. Of course, the witness couldn't travel into Australia, they would have to give evidence by audio-visual link. There was significant evidence raised in Motorola Solutions that the taking of evidence by video link in China would not be permissible under Chinese law. So they may be committing an illegal act by trying to give evidence by audio-visual link. The second case, Hain Developments and Commercial Business and the Commercial Business Centre, contain the same factual scenario. Again, witnesses in China trying to give evidence by audio-visual link, which arguably is illegal under Chinese law. But it went a little bit further and discussed the fact that there'd be significant delay and inefficiency in providing that evidence. The witnesses were located in China, they had interpreters who were located in another venue, the legal practitioners were located in another venue again, and then the courts located in another venue. So there'd be significant delay in going back and forth translating the evidence due to the remote location, causing significant delay and inefficiency. Justice Rob found that that meant that it fell into the exceptional category. Because it falls into the exceptional category, adjournment was granted. In Robert Smith, it's a very simple case on the principle that that case involved issues in national security, information being put to the witness. That information would, because the hearing was to be run remotely, that evidence that would be put to the witnesses by Microsoft Teams. We've all heard of the Zoom bombing, of people dropping into different online forums that are being run. There was no guarantee that information could be securely communicated. So as a result, the hearing was adjourned. Quince and Quince, finally, is quite an interesting one. New South Wales Supreme Court decision. It was whether or not the hearing could be adjourned based on the cross-examination of the defendant on matters of credit. In that case, there was little documentary or other circumstantial evidence. And it would very much rely upon assessing a witness' credit in those circumstances where there's little documentary or other evidence. The facts of the case concerned whether the transfer of shares were forgeries, whether particular transfers were forgeries. And in that case, the judge adjourned the case to a point where it could be heard in person. In contrast to the previous authorities are the authorities of when an adjournment application has been refused and the parties have been forced on and forced to run a hearing by virtual hearing. Australian Securities and Investment Commission and Get Swift Limited. In that case concerned 41 witnesses. They were all to appear by Microsoft Teams, and it had two defendants who were based in New York. At the time it was put to the court, these two defendants were at the epicentre of the pandemic. The court found there were significant difficulties in running a remote hearing, but nevertheless they should be overcome. The court referred to Section 37M of the Federal Court of Australia Act, that it had a responsibility to facilitate the just resolution of disputes as quickly and efficiently as possible. Were it to adjourn this particular matter, that had a knock-on effect to all the other matters that were coming up before the court. Justice Lee drew on previous experiences in the court, successfully using Microsoft Teams technology. By that stage, there have been a number of other virtual hearings. There have been evidence of how that worked. It said that the witnesses would have to give evidence by audio-visual link, but they would not have to give evidence in chief because all of that had been contained in affidavits. That the court could still assess the witness's demeanour and perhaps even would be in a better position to do so because they'd be close up on the screen. And senior counsel indicated a willingness to cross-examine New York witnesses at a time that was convenient to them. The court said that it would sit outside of normal court hours. The court stated that either party was able to revisit the issue of an adjournment, and then the court would show some latitude in relation to that. It was also, as I said, aware of the disruptive nature of an adjournment and the knock-on effect to other cases. Captic and Ford Motor Company is another case that considered adjournment. His Honour went through a number of, I think it was about 10 different potential difficulties that could come up during a virtual hearing and how each of those difficulties could be overcome. Some of those included internet connection issues, which they found wasn't insurmountable. Practitioners would not be in the same location, but they could communicate by other means. My favourite quote from that is that receiving whilst in full flight a WhatsApp message with a document attached is not the same experience as having one's gown tugged and a piece of paper thrust into one's hands. So there are virtual ways you can tug on your senior counsel's robes, but those virtual mechanisms didn't mean that the person was denied a fair hearing. It simply meant that you ran that hearing in a different format. Expert witnesses could be conferred with remotely. Hot tubs could happen on virtual platforms, etc. Justice Perham found that the witnesses was unlikely to be coached. Remember, as opposed to quints and quints, this action was a class action about defective gearboxes. As a result, there was a very limited nature of evidence that they were giving, and he found that it was unlikely that those witnesses would change their evidence or be coached in that. He considered looking at it as a forgery hearing. He might consider adjourning the matter. So there's no conflict between those two authorities. His Honour found that cross-examination on an online platform could be beneficial. You had a close-up of facial reactions of the witnesses, etc. And the final authority of GK Australia demonstrates, I think, where we're up to now. That the ability of counsel to see or to read the court during an appeal was not a sufficient reason to adjourn a hearing. In that case, although it's not ideal, that the court or practitioners or staff members might have to work from remote locations, they could do so. Senior counsel, junior counsel and solicitors could communicate through online mechanisms as well. So in summary, I'd say that the COVID pandemic has obviously changed the commercial and legislative landscape, but it's also encouraged practitioners to think in new ways about how hearings might be run, and also to think about what might be commercially beneficial for their clients as well, which of course will turn on the individual facts of the case. Are there any questions?
I've got a question, Carmel. If you've got a case where you've got, say, commercial lease or any lease where COVID's changed the nature of the business, for example, a student accommodation premises with overseas students that can't come, would the mandatory negotiations and that sort of thing be a relevant factor if the court was considering a frustration argument, or would that be irrelevant, or do you have any views on that?
You'd be thinking of the Royals Hotel case that you talked about
It
in your
did pop into
presentation.
my mind, yeah.
I'd say that there are two separate actions that you're running. And again, whether or not the lease is frustrated really depends on the length of time in which that hotel or whatever operates. So perhaps an international student accommodation which only caters to international students and is set up in such a way to cater to them that it's located in the middle of a university. No one else is going to want to stay there. Aside from students, the university is now operating completely remotely. You would then look at the length of time for that lease, for example. Arguably, that lease would probably be a decade or more. The level of time that an international student couldn't attend for face-to-face classes might be a lot less than that. So it might be a year, but then you'd look at most, but then you might look at the relationship between that and the length of the lease. So I'd refer to the Hong Kong authorities and the authority from New South Wales, from the Queensland District Court in terms of that as well. So arguably it hasn't been frustrated because of that. It depends on the length of time when you're unable to use the premises. Maybe you can use the premises for other means. Maybe there are local students that can use those premises, etc. But the second relief that person might seek would be relief under the COVID measures. So they've then got the option, they've got the ability to negotiate the rent, and that means that gives them some sort of relief over that period of time. Perhaps, I don't know, I mean, it'd be interesting to see the argument run whether that negates the frustration because you've been able to use the premises in another way. Or if the terms of the lease are that it's only for student accommodation, in which case you can't use the premises for anything else. But I think in terms of frustration, I'd look at the length of time when the premises could be used. And that would be the main thing that I'd look at. The COVID, what they can claim under the regulations, I'd look at as being this is another option, another relief that's available for your client. So you're running two sort of matters, but I wouldn't say that there'd be very much success in running that as having the matter frustrated. Again, with the other authorities, you've got to look at the entire deal has changed. You know, King's now no longer walking down the street outside the rooms that you've hired, or you know, it's completely frustrated. The music hall is completely burnt down. It's to ashes to sort of look at whether or not it's frustrated. So, any other questions? No. Thank you.
Thanks very much, Carmel. In closing, can I just make a few points? First, can I congratulate both Carmel and Jonathan for presenting a COVID seminar that did not refer to a cat filter. Secondly, can I thank all of you who came to Chambers for the presentation and all of you who attended online. Thirdly, can I remind you that the papers, and I thoroughly recommend each of these papers to you, are on the Greenway website. And with that, I wish you a good night and thank you to all.